I'm Amy Wyrick. I'm the district attorney from the 30th Judicial District, which is Shelby County. My job every day as a prosecutor is to do the right thing for the right reason. That's it. And to get to do that every day for the citizens of Tennessee is a great honor. It depends. Typical lawyer answer. A lot of it depends on how complicated the case is, how many witnesses there are. A lot of it depends on the judge. Some judges like to work very long days into the evening. They like to work the weekends. Some judges don't. So there's a lot of different factors, but I can assure any victim in the state of Tennessee that the prosecutor handling the case is going to do everything they can to keep the case moving so that that trial is not drug out unnecessarily. Unfortunately, crime happens at a much faster rate than we are able to dispose of them in the courts, but we do the best we can across the state. Every jurisdiction is different. Some of them have many more cases set for trial than others, but we do the best we can to get those cases. If a defendant wants a trial, get that case set on the docket and do everything we can as the state to get our proof ready to go so that when that trial date comes, if it has to be continued, hopefully it's not going to be continued because the state hasn't done their part. Sometimes the defense attorney isn't ready. Sometimes the judge isn't available. Sometimes things happen with witnesses' lives and they're just not able to be there for the trial that week. You want to make sure that you are not moving so quickly that mistakes are being made, but also keeping the pace of the case moving, getting the witnesses on the stand, because you don't want the jury to get frustrated with a lot of delays. But a lot of it is beyond our control, but everything that we can control, we do everything we can to keep those trials moving because we know how important that closure is to the victim. I meet with every victim's family on every homicide case. Of course, for many, many years before I became the district attorney, I handled cases in the courtroom, so met with thousands of victims and their families over the course of my career. But I meet with all homicide victims' families in Shelby County, and then of course any and every victim who calls the office, emails the office, writes the office, of course I'm going to reply, I'm going to help and answer their questions, listen to them, listen to their frustration. Both, yes. A defendant can ask for a jury trial, of course. A defendant can waive their right to a jury trial and ask for a bench trial, but we as the state may want to submit the case to a jury. We may not want to waive that right to a jury trial. So it just depends on the prosecutor handling the case, the victims, of course, what concerns and issues the victim might share with the prosecutor, and also what the defendant wants, what his constitutional rights are and how he or she want to exercise those constitutional rights. I'm always thankful and grateful, and have been for the 30+ years that I've been a prosecutor, of the willingness of community members to step up and do their job as jurors, because without them we can't do our job seeking justice. The same with witnesses, people who are willing and able and do participate in the criminal justice system. We can't prosecute offenders without those witnesses. Prosecution's going to be at trial. The state of Tennessee will be there. Sometimes, depending on how big the case is, it might be 2 prosecutors, it might be 3 prosecutors. You're also going to have probably a victim witness coordinator from the DA's office that is assigned to that case, probably an investigator from the DA's office assigned to that case. The judge, of course, is presiding over the case. The defendant will be there, or defendants, if there's more than one, they will be in the courtroom. Their lawyers will be there, and then whatever staff that the lawyers may have in court with them for the trial. There will be court clerks that are there taking down everything that happens in the court, keeping up with the files, keeping up with the paperwork that is there. There will be a court reporter who is taking down every word that is said in the criminal court so that that record is around forever. And then, of course, if it's a jury trial, the jury will be there. Maybe 14 of them, maybe more jurors, depending on the complexity of the case. And then last but not least, the sheriff's deputies who are there to keep things safe, to protect, and just keep an eye out for everyone's safety. Before you testify, you can't be in the courtroom. So unless you are the victim's family on a homicide case, you have a right to be in the courtroom from the beginning to the end. But most witnesses on a case are going to be outside of the courtroom until they testify. And then after they testify, they are allowed to sit in the court and watch the rest of the trial. We don't want witnesses to hear what other witnesses have said, right? Because then it doesn't look as if it's coming from a place of truthfulness. It looks like it's just coming because that's what you heard the guy before you say. So it makes sense to have that rule. It is one of the rules of criminal procedure that witnesses be sequestered, but there's a reason for it, and it's that. What we always tell witnesses, you got nothing to worry about as long as you just tell the truth. That it's okay to say, I don't know, if that's the answer to the question. I don't remember, I don't know. But as long as you're telling the truth, you got nothing to worry about. We may sequester the jury at a local hotel and keep them separated from their family while they're doing their job of service. But depending on the type of case it is, how much publicity the case might have gotten before it got to trial, depending on if there's been threats to witnesses or parties of the case, then we may sequester the jury. Under the law, the judge has to instruct the jury on the law that applies to the case. And that's based upon the facts that have been presented, what the jury has heard. And the judge gives not only the most serious charge, but oftentimes the judge gives the lesser charges. And sometimes jurors come back with a verdict of one of those lesser charges. And that is their providence. You know, they are given a case. It's difficult for a prosecutor to hand a case over to a jury because as a prosecutor, you've lived with that case sometimes for years. You've gotten to know the victim's family, you've gotten to know the witnesses, you know the case inside and out, and you've now spent a week or maybe 2 weeks presenting everything, all of the witnesses, all of the evidence, they've heard everything, and now you're putting it in the trust of this jury to do the right thing, to listen to the law, to take the facts that they've heard, to apply their common sense, and to come back with that verdict that truth dictates and justice demands. But sometimes jurors do find for that lesser charge, but that's certainly their right to do so. It's a communication between the prosecutor handling the case, the defense attorney, and at the end of the day, it's something the defendant has agreed to. The defendant has said, yes, I will do this. And it gets a bad rap, I think, for reasons that are mainly based in the fact that people don't understand the volume of cases that we have as state prosecutors. We don't get to pick and choose what cases we handle. We get everything that comes through the door. And plea arrangements, plea agreements, if we didn't have those, the criminal justice system would break because we don't have enough judges and prosecutors and defense attorneys to handle every case to a trial. So this idea of plea agreement is not a negative thing. It gives that closure to a victim. We're not going to dispose of a case unless and until we've gotten a victim to say, yes, that's fine with me. But it keeps the system moving and it provides that closure to a victim.